Good afternoon, everyone. Thank you for joining us today for the ConsensusDocs webinar, How One Owner Revamped a Public Construction Program Through Better Contracts, Better Technology, and Better Project Delivery. Hello, my name is Brian Perlberg. I serve as Executive Director for the ConsensusDocs Coalition, and I'm located in the Washington, D.C. area. I'm serving as today's moderator, and I'm really excited about today's program. ConsensusDocs is the only standard construction contracts that offers 100 standard construction contract documents and are written and endorsed by 40 leading design and construction associations, including owner groups like COA, CURT, and NASPA. Now for today's program, you're encouraged to ask questions throughout the program, which you can do so by clicking in the questions box and then typing in the question. I will either take the question at the time of the presentation, or we have a formal question and answer session at the end of the webinar. Now, as a participant for today's webinar, you will receive the entire slide deck, the PowerPoint presentation, in two formats. You'll get it in PDF, so you will have a copy for yourself, and you'll also get a copy in which you'll have the PowerPoint slides and the audio portion. That's always the number one question we get. So be assured that you will get a copy of the presentation as well as the audio. Now, we have a great audience today. We have about 100 attendees or office locations, and you're going to get to hear firsthand about an experience from a public owner that has made a dramatic improvement, and I mean really dramatic improvements in their construction program. With that, let me introduce today's speaker, Ryan Lamb. Ryan serves as General Counsel for the Iowa Department of Administrative Services. In this capacity, he is the Chief Legal Officer for the state's General Services Enterprises, which includes construction and procurement, accounting enterprise, human resources enterprise, and information technology. Ryan leads the state's labor relations team as well. He holds a bachelor's degree in civil engineering from Iowa State University, and a law degree from Drake University. He's an attorney and engineer in the state of Iowa. Prior to joining the state government in 2001, Ryan specialized in construction litigation with the firm Whitfield & Eddy, PLC in Des Moines, Iowa. He's a contributing editor for several publications, including Wiley's 50-State Construction Lien and Bond Law and Aspen's State-by-State Guide to Construction Contracts. He's a member of several professional construction organizations, including the Associated General Contractors of Iowa, Master Builders of Iowa, the Mechanical Contractors Association of Iowa, and the ACE Mentoring Program. He's also a JAG officer in the Iowa Army National Guard. Ryan lives in Colfax, Iowa. With that, Ryan, please take it away.
Thank you, Brian. Pleased to be here to talk about the improvements that have happened at the Iowa Department of Administrative Services. On this first slide here, you'll see my contact information. My cell phone is posted there too. Please feel free to contact me with questions and to email me at any time. Thank you again for listening today. I'm going to turn to the next slide. What happened, when did it happen, and what are the highlights? We modernized the state's construction program. The changes occurred during 2011 following the election of Governor Branstad and the appointment of Mike Carroll. We adopted the ConsensusDocs. We, in essence, privatized our construction program. We improved our technology, and as a result became a more sophisticated owner. Governor Branstad is the soon-to-be longest-serving governor in the United States, assuming he wins his upcoming bid for re-election. He was the 39th governor of Iowa, serving from 1983 to 1999, and is currently the 42nd governor of Iowa, serving from 2011 to present. Governor Branstad appointed Mike Carroll as the director of the Iowa Department of Administrative Services, and the acronym for the Department of Administrative Services is DAS, or DAS. So throughout this presentation, I'll often refer to the department as DAS. Branstad appointed Carroll as director of DAS in 2011. Prior to that, Director Carroll led a successful construction company in the Des Moines area. He personally has more than 35 years of experience in commercial construction. In addition to increasing jobs, increasing the family income, and improving Iowa schools, Governor Brandstad's goal at the time he took office in 2011 was to reduce the cost of Iowa state government by 15%. As you will see, the effort to improve DAS construction aligns with that goal. Said another way, Director Carroll identified a program within DAS that, if improved, could result in both short-term and long-term savings for the state of Iowa. Despite the challenge, Director Carroll undertook that effort to change DAS's construction program. How did I get here? Why me? I was named General Counsel of DAS in April of 2011. Before that, I practiced law with a firm in the Des Moines area, Whitfield Nettie, which is known for its construction law practice. I consider myself lucky to have been mentored by who I believe to be one of the premier construction lawyers in the Midwest, John Templer. I was a civil engineer before I went to law school. I did development design, wastewater treatment plants, storm, sewer improvements, etc. And I also represented an AGSC affiliate in a lawsuit aimed at increasing the number of jobs that go to Iowa contractors as opposed to out-of-state contractors. In addition to my work at the engineering firm, my family is also construction-oriented. My father and brothers have both built their own homes, and most of my colleagues and friends and peers are in the construction industry. The transition to DAS was an interesting one. One weekday morning while working on a file at Whitfield Nettie, I received a phone call that I answered by speakerphone. I answered that call by speakerphone because I wanted the senior partner I was working with to hear the call, as I was expecting a call from an important client. The person on the other end of the phone didn't beat around the bush and really stated that he was the director of the State Department and that he needed to come work for him as general counsel. At that moment, the senior partner I was working for was sitting at the door. The person on the phone on the other end of the line was Director Carroll. He invited me to his office to discuss the opportunity. During that meeting, I told Carroll that my acceptance of his offer was based in part or conditioned upon commitment to make improvements in the state construction program. Carroll definitely fulfilled his promise. What is DAS? DAS is a State Department in Iowa's executive branch of government. From a responsibility standpoint, it is arguably the biggest and broadest department in Iowa's executive branch. It was created in 2003 to improve the state's operations from an efficiency, service level, compliance, and consistency standpoint. Prior to its creation, the various agencies in the state separately managed their own accounting, information technology, human resources, and general services. The goals for DAS are set by Iowa's legislature. However, those goals have yet to be achieved. Consolidation of services and the transfer of authority and responsibility for the provision of those services has been resisted. These challenges making an agency like DAS work for the benefit of the state a constant battle. Under the third prong on the slide there, you'll note that DAS is responsible for, actually the third prong on the second bullet point of the slide, you'll note that DAS is responsible for human resources. As Brian mentioned, my responsibilities also include leading a team of labor attorneys. Those attorneys handle grievances for the state by our employees. In accord with the governor's direction, DAS is working very hard to improve the state's ability to manage labor. We recently concluded negotiations with the state's largest labor union. Although we failed to bring about significant change to health insurance offered to the members of the union, we were able to negotiate a wage freeze and thereby save the state millions of dollars. Important to note in this presentation with respect to our ability to make improvements, and in particular the change in contract document, is that central purchasing and or procurement is also within DAS. Construction and central purchasing are certainly separate, but they both ultimately report to the director of DAS. Central purchasing has daily control of the procurement processes, and more importantly, For purposes of this conversation, the terms and conditions of state contracts. A very important part of making the improvements to DAS construction was the fact that central purchasing and construction were joined together on the need for a change. The leader of our procurement area, along with the leader of our construction area, and the people that they report to, work together to bring about these changes. Throughout this presentation, I loosely refer to DAS as a construction program, or the DAS construction area as a program. DAS construction is officially titled the Iowa Department of Administrative Services Design and Construction Resource Bureau. The key word here is Bureau. The organizational units of Iowa's government are actually prescribed by law, by Iowa Code Chapter 7E. Note that while the units are prescribed, the legislature has nonetheless reserved for directors of state agencies the ability to reorganize the structure of their departments. For DAS, the legislature stated in Iowa Code Section 8A104 that the director is duty-bound to develop and implement policies and procedures designed to ensure the efficient administration of the department and to establish the internal organization of the department and allocate and reallocate duties and functions to subunits of the department to promote economic and efficient administration of the department. The bottom line here is that it is clear that from a statutory standpoint, the director is authorized to make organizational changes to his department, including the organization of DAS construction and the manner in which it is administered. For other public owners, I imagine that finding that statutory authority to make the change is probably one of the biggest hurdles to actually accomplishing that feat. One of the first things we did here was to verify that and determine that we did indeed have the authority to make the changes necessary to improve our construction program. Before 2011, in process, we had 125 projects valued at $300 million. We averaged 68 projects per year completion, and on a dollar value standpoint of projects completed per year, you can see that the number is about $40 million. Traditional project delivery method, projects are managed by state employees, AIA contract documents with heavily modified general conditions, and we have limited technology. Iowa is one of just a handful of states that does not allow any form of design build on public improvement projects. I should caveat that statement about that prohibition with the recent developments here with regard to our university system. That prohibition may not apply to our universities, but for other public entities it certainly applies, and that restraint is Iowa Code Chapter 26, which is intended to be a benefit for the taxpayer to make sure that projects and contracts are fairly awarded, and certainly is a benefit in many senses. Although it lacks some flexibility, it definitely provides or ensures a fair means for ascertaining vendors to perform work paid for by taxpayer dollars. That statute requires that designers and contractors be separate entities. The designer prepares the plans and specifications. Those plans and specifications are then required by law to be published in a newspaper. Sealed bids are received before a time certain and then opened and announced at a public bidding or a public bid opening. By law, the low bidder gets the work unless the government entity determines that the bidder is not responsive or that the low bidder is not responsible. And I misspoke there actually. It's not, the bidder would not be responsive, the bid itself. The bid must be responsive. The bidder must be responsible. While the owner is vested with actually a lot of discretion with respect to determining whether or not a bidder is responsible, that is nonetheless still a difficult process for an owner to undertake. This traditional procurement and project delivery method, as I said, is prescribed by Iowa Code Chapter 26. Before 2011, 7 persons with a variety of professional backgrounds, managed the state's construction projects. Some were architects, some were engineers, some had little or no experience in construction. All of them, however, were excellent people who followed a system that had been in place for decades. The paperwork trail was, however, massive, and the duplication was everywhere. For example, a separate document that merely restated the terms and conditions of the contract and contained the signatures of the contracting parties was created to document the construction contract. In a few slides from now, I'll show you a copy of that document. By the time a contract was ready to go, it had to be signed by 6 to 7 different representatives of the state. Needless to say, the time and the process consumed a lot of effort and resources that could have otherwise been spent on moving the project forward. DAS was frankly notorious for its poor management of construction projects. There was little technology, no scheduling software, no accounting software, no drafting software. There's minimal use of BIM. I think there was one project at the time that had taken advantage of BIM, but it was experimental. Projects were rarely completed on time and hardly ever within budget. The change order process was not followed rigorously. It was frankly misused by DAS designers and contractors. In a minute here, I'll also show you the little boat behind the big boat analogy for the change order process that I hope generates a laugh. Formal disputes were virtually guaranteed on our projects, large and small. All litigation ran through the Attorney General's office, and that's prescribed by Iowa law. Iowa Code Chapter 13 requires that any time a lawsuit is filed that the Attorney General represents the state. Decision-making of any sort was very slow, and resolving disputes was next to impossible. There are few, if any, experts involved from a construction standpoint. Little thought was given to business practicality and the effect that one dispute has on other areas of the same project, on other projects, and on team morale. The state used AIA contracts with the designers and contractors. The general conditions were severely modified by the state through time. The modifications included expanded contractor responsibilities for site conditions, errors in the plans and specifications, and contractor coordination. It is important to draw attention to the second and third statistic on the slide, which I already mentioned. In the 5 years prior to making the change in DAS construction, DAS averaged 68 completed projects per year, which totaled $40 million per year. 2 slides from now, you'll see a comparative statistic that does an excellent job of demonstrating our improvement in this area. I found this picture on the internet. I'm probably violating some copyright somewhere, but it was on the internet, so it's out there. It's a picture of a little dinghy behind a yacht. As you can see, the little dinghy is titled The Original Contract. The little dinghy is attached to and apparently usually pulled along by the large yacht called the change order. When I first arrived at DAS, I had one of our employees call me into a room, and he drew that picture up on the board and said that in his opinion this was the way that contractors were able to take advantage of our construction program. Our inability to coordinate with designers and to work with contractors created lots of cost overruns in the form of large change orders.
Ryan, this is Brian. Let me just interrupt you just a quick second there. I think that's a really good graphic, and it's telling, right? I mean, so since DAS has made some changes, one of the things that's probably true is that this concern about that the change order is a way for a contractor or constructor to get to be financially solvent is maybe even more true today. With the financial collapse, at least in the past couple of years, you have multiple possibly responsible and responsive bids, but the only way that they're essentially, what I hear is that that contractors are essentially buying work that the original contract couldn't even buy you a dinghy boat, that they just really did it to kind of stay afloat business-wise. I mean, any thoughts as to if that, from your perspective, if it's gotten worse, at least the environment in which, as an owner, you're trying to solicit bids?
Well, frankly, we still face that problem as a result of that traditional design bid build project delivery system that we're constrained by, and contractors are certainly still hungry in the market. However, I do think that the projects that we have, they do seem to draw in a very small sliver, frankly, of Iowa's construction contractor market, and I haven't heard that they're buying as much work as they used to have to. I think a lot of that is because we do a better job with our plans and specifications, and we do a better job administering our projects using our construction managers. So certainly there's still that element, because the law, in essence, requires us to take the low bidder.
Yeah, and just to be clear for the audience, when I say buy work, I mean that there's so much competition for the low bid, and you're judged on your price and only your price. The only way to get a project is to take it at a loss. So you're essentially, instead of making money, you're buying a project. Is what I was, and I think you took it out.
One other thing that we do is we do rely upon our construction managers to help us take the really big project and divide it up into several different smaller projects. And I'll talk about the CMA method here in a minute, but we do have, if there's a large construction project, it's broken up into different packages, which does a better job, I think, of distributing the work among contractors, so that they don't have to buy the big project at the risk is smaller with respect to bidding our work as a result of the smaller packages.
Good.
We frankly found that to be a benefit. Yeah.
Yeah. Yeah, so when you had the bigger packages, it was sort of maybe the government, DAS, was trying to protect itself from all contingencies that didn't coordinate well, and led to, essentially, by trying to protect itself, it sort of hurt its position from setting up more change orders, sounds like.
That's true. We do a lot. There's a lot more work on the front end from our standpoint with respect to having a good understanding as to what the project requirements are going to be, and breaking them down into smaller projects sort of puts more of that onus on the CM and the designer to make sure that the projects the project plans and specifications for the various packages are accurate. And I think that helps with the contractor being able to put in a bid that contains less risk. It also helps with budgeting, frankly, so from our standpoint.
Excellent.
So there's a copy of the what was referred to as the AGA, Accountable Government Act document. As you can see there, it's got the phrase Exhibit A on it. It was literally, that exhibit was attached to every contract. And if you look in the left-hand column, it identifies the task that the vendor, aka the contractor or the service provider, must perform successfully before he or she, or before it would be paid. In essence, it is really another contract. I'll flip to the next screen here. It's also signed by the both the director of DAS and the representative of the company. The problem with that is twofold. One, we had one person, I believe, designated full-time, not full-time, a full-time employee who spent a large portion of his time creating these AGA documents for every single contract. And he was not an attorney, but he would nonetheless go into the contract and identify what he believed to be the material requirements of the contract, and then create this document, have it signed. so he had to spend a lot of time on it. Secondarily, it in essence created another document outside the contract that arguably was a contract and created a conflict in documents potentially if a mistake was made or an oversight. And you can see that by the fact that it's a two-page document rather than an entire form contract along with the other supplemental terms and conditions, that it certainly didn't contain all the detail of a regular contract. Good people reviewing the law, trying to make determinations as to what was required on our construction contracts, but with just with, frankly, a misunderstanding as to what was actually required. The Accountable Government Act required us, in essence, to have a contract with the vendor that clearly set forth what was required of the vendor and before we'd make payment to them. And that statute was misinterpreted to require us to create actually a second document. Good intention, but a lot of extra work that was unnecessary and, frankly, was problematic. After 2011, there are 321 projects valued at $495 million that are active and have been completed. You'll see there the 98 projects completed per year. I'll talk about that in a minute. $80 million of projects completed per year. We now have we contracted with construction managers to assist in our delivery of the project. Those construction managers manage our projects in the same way that the former employees managed our projects. We've also adopted new technologies, project management software. Our contracts require the critical method, require that the contractor show the critical path method at the time of the bid, and we also use them more frequently. We also switched to the ConsensusDocs. There are currently 6 different construction management firms on contract as construction manager agents. The firms were selected using the state's competitive proposal process. That is, they submitted proposals that set forth both their qualifications and the charge for their services. The CM contracts are 1-year renewable service contracts. Projects are assigned to firms based on experience, availability, and the location of the project. The CMs are the eyes and ears of DAS. Adding a construction manager as agent to the process was and is a means for DAS to add a construction professional to the project delivery method without veering outside the requirements of Iowa law. Unlike design professionals, the CMAs working for DAS are experts in construction management, in particular scheduling and project administration. Although there is no per se shifting of contractual construction responsibility, or for that matter design responsibility, the addition of the CMA makes DAS a more sophisticated owner than it was under its past model. DAS has, in essence, privatized the management of its construction projects. Said another way, the duties performed by government employees are now performed by vendors of the state. Those vendors are held to standards set by the industry and by their contracts. Their rights are defined by a service contract rather than by a collective bargaining agreement or a merit system. As a result, the state is able to hold the vendors to a greater level of performance than it could its former employees. Key to the successful implementation of the construction manager and project management is inclusion and teamwork. Because the construction managers are already on contract, that is, we already have those 6 firms on annual contracts. DAS is able to bring them into the project process at its infancy. The construction manager, on behalf of DAS, then sees the project through from its start to its completion. This early inclusion, along with frequent and effective communication, is vital to our construction success and our team morale. Before moving on to technology, I should note that DAS has taken that same teamwork approach in the formation of its relationship with its architects and engineers. Like our CMs, designers are held to the industry and contractual standard. Despite those high expectations, DAS conveys to all of its service providers that collaboration is the key to achieving the shared goal of completing a successful project. DAS now also uses web-based project management software. As I mentioned before, we also require a critical path method schedule and require submittals and updates of those schedules. These particular technological improvements have no doubt made us more efficient and accurate from a project administration standpoint. As I mentioned before, there are 321 projects that have been completed or in process, but there are currently 125 projects in process valued at $415 million. So the 321 projects number includes both projects completed and those in process. In process at this time are 125 projects. Their value is $415 million. A couple slides ago, I pointed out that the average annual completion rate of projects by DAS was 68 projects per year at a volume amount of $40 million per year. Today, following the changes made, the average completion rate of projects per year is 98, and the average volume or value of those projects completed per year is nearly double the prior amount at $80 million, $80,300,000.
Ron, let me interject. Those are incredible results of essentially doubling the productivity of the amount of dollars put in place per year. Are you at all familiar? How does this? Have you heard of any other kind of owner across the country getting those kind of results? I mean, it's so dramatic. It's hard to believe that you're able to achieve them. Are you aware of anybody else who have had similar kind of results?
No, I'm frankly I'm not. But I do have. We have three representatives of the state right now at the COA conference in San Diego. They're going to give a similar presentation, I believe. It's more acutely focused. I'll talk about that in a minute on a particular project, and they might be aware of it, but I don't think so, and I think that's why one of the reasons we're being asked to talk about it. So no, I'm not familiar of anybody else in the public sector who's been able to do this. But I think a lot of it comes from the fact that and I'll talk about this at the end too, there was a real need here to make a change. So we responded to a problem and corrected the problem, and correcting the problem has resulted in statistics that look just frankly really good. I think that's because we made good decisions, but also because we had a significant problem. How do we change the consensus docs? We identified a need for a change of construction contract, or at least to an improvement in the contracts that we were using at the time. The existing contracts were criticized by many in the construction industry. Within DAS itself, many found the documents cumbersome, unfair from a risk allocation standpoint, difficult to administer when the need for a change arose in the project, and a roadblock to resolving disputes. In response to that need, we proposed a reasonable solution. Upon concluding that the changes were necessary, whether that be to the existing contract or to a new contract, DAS collected all of the various forms of contracts it was using on its current projects. Those form documents were reviewed and shared with others. What we found was that the form documents had been severely modified by this state. The modifications were actually longer than the original contract itself. Changing the contract form appeared to be one solution to fix that problem. Rather than setting on our own to fix it, we sought to make the improvement via collaboration. DAS reached out to construction industry professionals for feedback and recommendations. We sought input on all aspects of our construction program, including not only our contracts, but the way they're administered, the accounting of them, etc. DAS met with construction industry groups, including the AGC, the Master Builders of Iowa, the Mechanical Contractors Association of Iowa, and other subcontractor groups. We met with designers, representatives of the AIA, individual architects and engineers. Met with financiers and lending institutions such as Wells Fargo. We also met with industry leaders and large corporations like Pioneer DuPont. DAS also met with sureties and insurance companies, including Holmes Murphy. We didn't just collaborate, though, with industry groups. We also sought out partnership from our other leaders of Iowa's government. We met with representatives of the Attorney General's Office and the Department of Management. The problems in the construction program at DAS were observed and recognized by others. They, too, agreed that there was a need for improvement and were supportive of changes that would benefit the state. The change in delivery method, along with the change in contract document, was explained and approved. We also made an effort to collaborate with our customers. I believe I mentioned at the outset, or on one of my slides, and DAS is charged with providing services to the other agencies of the state of Iowa. So what we do ideally needs to be something that that our agency customers buy in and believe to be a good way of doing business that results in a better product for them. At the time, agencies were no doubt dissatisfied with the level of service they were receiving from DAS on construction projects. They were frustrated by our inability to meet a completion deadline and to stay within budget. And those are the two big things for another government entity, is that they are receiving appropriation from the legislature to have a project completed within that appropriation amount. They usually have a need to have the facility constructed so that they can provide their service to their taxpayer consumer, whether it be the Department of Human Services or the Department of Corrections. They provide services to folks outside of state government, whereas DAS provides service to folks inside of state government. DAS needs to be sensitive to that concern or that need to provide the service outside of state government, and therefore meeting the completion deadline is especially important, and at the time it was very difficult for us to do that. DAS is also making an effort to communicate the benefit of the changes to the taxpayer. In fact, part of the purpose of me providing the seminars to spread the word, the benefit that the state has experienced as a result of the change. And as I mentioned before, Brent Carr, the leader, who's actually the leader of DAS Design and Construction Resources Bureau, along with others, are right now in California set to present at COA. Again, as I mentioned, to talk in particular about a project, a dramatic change at the Iowa Veterans Home in two projects completed there, one that was started before the change and one that was started after, and to show the significant improvement experienced by Iowa Veterans Home with respect to the administration of construction projects by DAS. Statutorily, and this, as I mentioned before, for public owners, this is one of the most important aspects. Statutorily, that the Iowa legislature vested DAS with both the responsibility and the authority to administer construction projects for the state. And when I say the state, I should caveat that real quick by noting that the Board of Regents, the National Guard, and the Department of Transportation do not use DAS for their construction projects. We primarily handle construction projects for the rest of the executive branch, minus those exceptions. Statutorily, the director had an obligation to undertake change to improve the DAS construction program, and despite naysayers, which there were certainly many, even if the changes made were not instantly popular, there was no doubt that change was needed. Using the information we had at the time, the change in project administration and contracts seemed to be a necessary part of that change.
Ryan, before we move to the next slide, let me interject with a question. Well, first off, could you talk a little bit about which standard consensus docs that you use as your template, and talk a little bit about, if I saw statutory authority, if you any resistance that you I don't know if I'm jumping the gun here, but any either changes that you made to the documents or resistance that you had in going to the new documents. I mean, I know you had some, but one, which documents you're using, and then talk about a little bit about if when you have statutory authority. I was thinking about did anyone ever claim that you couldn't use the documents, for instance, because of some statute?
Okay. With respect to the type of the consensus docs that we actually use, we use the 800 series, and as I mentioned before, we break projects up into packages, and we have a construction manager as agent. And when I say we break projects up into packages, that is an option. We don't always do that. That discretion is left to the project management leader, Brent Carr, and his team. If it's appropriate, we break it up, but we always have a CMA assigned to the project. Those CMAs are, in essence, a privatized version of the former employees who work for DAS. So the 800 series made sense as they include the construction manager's agent within them. With respect to the claim or concern by others that DAS didn't have the authority to make the change, no doubt I heard that argument all the time. Bottom line is that wasn't the case. Nonetheless, I did have an obligation about that. I had an obligation to achieve consensus with the Attorney General's office and with the Department of Management, as those two entities certainly have authority with respect to the liabilities of the state of Iowa. And one of the ways that we did that was we took the standard service terms and conditions that were created for all of the state of Iowa's contracts, and we reviewed those. We took those standard service terms and conditions and paired them up with the ConsensusDocs contract to make sure that any hole we had in the ConsensusDocs was either filled or that we could explain it away from an economic risk transfer standpoint. Not every contract's the same, and not risk sharing between a construction project setting is not the same as risk allocation in a contract for widgets. There is as long as we were able to, and I found this to be the case, as long as you're able to explain to others the reason for the difference in your contract compared to their contract, as long as you're able to explain that difference accurately and they understand it, that is when their minds become open to making a change to a contract. So bottom line is we took the terms and conditions created by the Attorney General's office and either incorporated them into the ConsensusDocs or were able to justify the reason for not having such a protection in the ConsensusDocs. But ultimately, when our final version of the contracts were shared with others, they make sense, and the risk allocation, the indemnification, the insurance provisions, dispute resolution, upon review and explanation, they were generally accepted. It was the initial fear of making the change more than concern upon actual review of the document. So,
do you think it's fair to say that some people, maybe ones who had the problem wasn't so acute, haven't evaluated sort of the current state of contracts and are afraid of making a change because of resistance to doing so as an owner?
That is fair. Yeah, and when I would take the service terms and conditions that we use for all contracts, take the existing construction contract forms, and then the proposed version of the ConsensusDocs with minor modification, and you compare the three. The contract that we proposed using was just clearly a better product than the contract we're using in the past. So.
And once you do it, is it fair to say that you create your template, your standard, and then that becomes your standard document for the most part going forward?
Yes, we don't create a separate contract for a unique contract for every different project. We try to use the the standard terms and conditions, that is our ConsensusDoc contract for every project. And there's always supplemental documents, of course, supplemental documents in the bid documents, et cetera. But we do use a form contract, and we use that for predictability purposes on the part of our vendors. We don't want our vendors have to be concerned about a unique set of terms and conditions on every project they bid. And additionally, we don't have the resources to create a special contract for every project. Those special conditions are addressed in our bid documents generally. Okay. Perceived benefits of our privatization. When I say our privatization, it's the addition of the construction managers into our system and ConsensusDocs. We're perceived, I believe, as to be a more progressive entity, more owner. Our contract document is more owner-focused. No disputes. I'll talk about that in a minute. If a dispute were to arise, our potential for resolution of the dispute is greater and certainly a more efficient process. And we also reviewed our insurance requirements. It's fair to say that the privatization of construction management and the adoption of the ConsensusDocs changed the image of DAS construction within the state and the construction industry. Unlike other form contracts, the ConsensusDocs are notorious for containing terms and conditions that are favorable to the owner. They're also, as their name implies, perceived by many to be a more fair contract from a risk allocation standpoint. Since the change was made in 2011, as I mentioned before, there's not been a single formal dispute on any of our projects where the ConsensusDocs have been used. Before the switch, formal claims and lawsuits were not uncommon. Delay and acceleration claims in the hundreds of thousands of dollars and sometimes in the six-figure range were made. When I first arrived at DAS, I literally spent 3/4 of my time meeting with designers and contractors to resolve claims. Since the change there has not been a single formal claim. To be clear, that is not the result of the state simply rolling over and paying for emissions in our plans and specifications. Instead, it's a result of a number of things, in particular the change to our project administration, along with the changes in our contract documents. We're very pleased in the change, and as you can imagine, in not having to handle or resolve as many claims. If a formal claim were to be submitted, our contract now allows for us to resolve disputes in what I believe is a far more efficient manner than our former contracts. The resolution process, the first step of our resolution process requires representatives of the parties to meet. It then goes to another level of representative of the party, a person with more authority. If those meetings fail, then dependent upon the project, the parties submit the dispute to a project neutral or dispute review board or to mediation. Finally, if the parties are unable to resolve the dispute after those 3 prior steps, they contractually agree to have their dispute resolved by an arbitrator rather than a judge. This dispute resolution process provides an efficient and fair system for resolving disputes that better enables or empowers construction persons and construction professionals rather than attorneys to find a means to resolve a dispute. Of course, being an attorney myself, I'm not intending to imply that one should not consult an attorney when a construction dispute arises. Instead, what we try to do, and what I'm trying to say, is that the construction contract should not prevent people from resolving disputes without getting attorneys involved. One should not be required to hire an attorney every time a dispute arises on a construction project. Finally, in the new contract, with regard to insurance, the insurance requirements of old were reviewed and modified to make sure that our vendors were required to buy insurance that was in line with the industry standard and current, rather than having one of our state employees. And when I first undertook this effort, I spoke with representatives in various sectors of government to try to nail down what the appropriate insurance requirements should be, and that was not a fruitful effort. And like hiring the construction managers to help us manage our projects, what we ultimately ended up doing was having our construction insurance requirements reviewed by a construction insurance professional, and we entered into a long-term arrangement with that insurance professional to provide us with frequent updates as to what we should be requiring our insurance to make our contracts competitive, and yet at the same time protect the state from unexpected accidents and problems. Again, like the change in contract and the change in our project administration, the change in insurance requirements resulted in the perception that our construction administration and our contract was reasonable, progressive, and sophisticated, and that we were making an effort to work with our vendor partners rather than to create an adversarial atmosphere that had unreasonable and unfair requirements.
Brian, let me ask you a question about, if I may. So you're using the 800 series of ConsensusDocs, the 801, the 802, and the 803, and I assume for the contract with the design professional, you're using the 803. Compared to the previous DAS contract, would you say that as far as the agreement between the owner and the design professional, I assume that it's a lot more detailed in the insurance requirements of the design professional than you previously had used in the modified AIA documents. Is that a fair assumption to make?
Yes, our insurance requirements in all three contracts, frankly, with the construction manager, the contractor, and the designer, were more detailed and were more detailed and more thoughtful. And we are not stagnant in that area, or at least we try not to be. We don't. Insurance changes, insurance requirements change, types of insurance change. So we regularly, or at least make an effort to consult with our insurance professional to make sure that they meet the industry standard.
Was it hard for you to determine which insurance professional to use to help with that evaluation?
It was. We spoke with a few professionals and ultimately landed on one that in Iowa. I mean, there are a few big ones, and we went with one of the bigger ones that also represents all sides of the insurance industry. So, and they're available, and they work with us, frankly, not just on construction contracts, but also on other contracts that we have for vendors. DAS Central Purchasing, which is a sidebar here, DAS Central Purchasing is actually responsible for buying all things for the state of Iowa. So we had a pretty, as you can imagine, there are lots of contracts out there with insurance requirements. We needed somebody who's also able to help us with those other contracts.
Now, getting back to your main points, so it seems like you really changed the culture and the experience that you've had. You essentially were, your claims history is just totally, it's incredible how much it's totally changed from before to now to then. It's just hard to believe it's been such a dramatic change. And is it just really a combination of everything, that it's the contracts, but it's the culture of you as an owner and use of technologies, or would you just say it's everything, or what would you most attribute it to?
I'd say that the ConsensusDocs are a part of the culture change of DAS construction, and that along with the ConsensusDocs was the privatization and then a reinvigoration of our people to have a goal of completing a project rather than an adversarial process. Our leaders are motivated to work with our vendors as opposed to having a contract that is used as a weapon between the parties. All as a part of the selection process of especially our construction manager and our designers, the teamwork aspect is stressed. And another part, I think, of that success is sometimes breaking those really large projects down into smaller projects, so that our construction manager and our team is able to work more closely with that trade contractor, so to speak, and taking away that intermediate general contractor who might otherwise, provide another channel of communication where something can get misconstrued or misinterpreted. So I think greater control, better contracts, better people, and all that has resulted in a better culture, and that better culture has resulted in less disputes. And the other thing is, I really believe that modified dispute resolution process, where you look to your contractor, you don't think that you need to hire an attorney every time a dispute arises, increases the chance that the parties are going to want to get together without attorneys to try to resolve the problem.
It's certainly, one of the things you've said throughout today is the collaboration, and in talking about it, and the communication pathways, and that the dispute resolution process with the communication, that sort of leads itself in. I mean, I know that it's actually in the contracts that says you'll do that. But what's funny is I go out to people who say, I'm interested in the ConsensusDocs contracts. One of the things that I like to do to evaluate whether to use them is to look at case history. And what's interesting is to hear you've used the documents a lot, the government's used the documents a lot, but because the documents are effective, they're not actually producing claims in case history. So it's kind of funny, I want to fall back on that black letter case law, but I personally think it's a good thing not to generate the case law from the fights. But anyway, I kind of share that vignette. One question for you is any thoughts the amount of savings that the state and the taxpayers may be experiencing as a result of not going to court and having the claims?
We haven't. I've been asked that question before, and I need to document it. To date, I haven't, except to show the rate at which we're able to complete projects on a faster basis. And we're still going through some of the. Actually, we're in the middle of a dispute right now arising from a project that was completed under the old regime. So we still don't have a total, couldn't total the amount of dollars that we spent as a result of disputes before 2011. So still working on it, need to get that done.
Good.
And with respect to not having any case law on a conflict arising from a project governed by the ConsensusDocs, I mean, contract law still governs, and parties' intent still governs, and in addition to the case law on a construction dispute applies to a contract governed by ConsensusDocs just like it would any other contract, from an implied warranty standpoint, from a statutory warranty standpoint. So I'm not, as long as the disputes don't arise, I suppose I can comfortably say I'm not super concerned about it, but I think it's a good thing, as you say. Perceived benefits of the privatization of ConsensusDocs and the ConsensusDocs. We have better designers. We use the competitive procurement process, or via the competitive procurement process, DAS is contracted with designers who value constructability and collaboration. The designer's role in the improvement of DAS cannot be overestimated. They too have adopted the ConsensusDocs, and despite some resistance at the start, have found them to be a contract that works. The privatization of construction management has resulted in better management of our projects. Project administration decisions are more predictable, more in line with the teamwork philosophy that is necessary for a successful construction project, and more timely. Designers and contractors know that the project managers they will be working with on a DAS construction project are some of the best in the market. DAS construction projects are completed on time. The focus on project planning, along with the increased level of skill and technology, has enabled DAS to set a more realistic deadline and to meet the deadline it sets. Our agency customers are thus better able to budget and plan for the use of the project. DAS construction projects are no doubt more controlled than they were in the past. The additional level of control comes about from a more active management of the project, a better design of the project, and a more collaborative teamwork effort during the construction of the project. The improvements designed and constructed by DAS's business partners are state-of-the-art facilities, the highest quality. The facilities are used for historical display, care of the state's veterans, the imprisonment of law offenders, and the care and nurturing of our children. We believe that the results speak for themselves. The numbers are the numbers. They show a greater volume of projects completed in less time without dispute. Our customers' opinions of DAS regarding construction has changed. Since 2011, there have been high-quality results, which has resulted in increased agency satisfaction. This hasn't happened by accident. There's been a lot of work. We are always flexible, always trying to collaborate and persevere to overcome challenges. Keys to success: know more about the subject matter than those who oppose it. And what I mean by that is, with respect to construction, I think there was an aligning of the stars, so to speak. The director of DAS was a construction business owner, and then the team he put in place were folks who were familiar with construction and had a good idea as to what particular things in the construction industry were resulting in positive changes and improvements to construction project management. Build support. Don't react to the problem, but seek out input from others and have them help you find the fix for the problem. Be sure to attain endorsement from the people that matter. There are leaders both within state government and from outside of state government that were instrumental in this process. Without their endorsement, the changes would not have been able to be made. Don't create a problem if you don't have a problem. If you have a problem and you make a change, having made that change will seem justifiable. At DAS, as I mentioned before, there was a problem, and the changes made were solution-oriented rather than just an effort to draw attention to the problem. And that is supported by the fact that our numbers show a better completion rate and a higher volume. And then teamwork. I've said that way too many times, I'm sure, but teamwork both within our leaders and with our vendors and with other entities in state government is very important to bringing about the successes that we've had. And that, in essence, is all that I have to say. I'm more than willing to consult with persons that would like information about DAS or about Iowa law concerning construction at the state. I'm happy to give credit to Mr. Perlberg. We reached out to him early on when we first thought about making the change to ConsensusDocs, and his organization provided us with a bunch of information that was very helpful to help bring about the change. The ConsensusDocs. Do you have any questions?
So we've got there we go with the slide with that. Well, I can't let that go. You know, Scott, let me ask you a question, though. I appreciate the kind words and with the ConsensusDocs team and stuff. I know you had some assistance locally, but weren't there some local factors? I believe that the Master Builders of Iowa and Scott and Revell were instrumental of making this change as well from an industry perspective, as well as I'm sure there are others on the changes that you made. Was that part of the experience and the success with the moving forward and the improvements?
Yes, one of the things, no doubt, that MBI and among others had identified the need for improvement to the construction contracts and the construction project management at DAS, and we formed a committee. When I talk about working with industry representatives, there were a number of very important folks who donated a bunch of their time to help go through the existing contract and to offer their feedback and recommendations as to what they thought we could do to make a contract that was more business friendly. And it wasn't, the effort wasn't to make it just contractor friendly, it was to improve our ability to do business with our vendors in the construction market. And so that included everything from our design consultants to construction managers to contractors, et cetera. And we met those folks. That included representatives from MBI, it included representatives from those businesses that I mentioned before, lawyers in town. A lot of people put in a lot of time to help come up with ideas as to how we could improve our system.
Well, good. Well, this is the time to remind you that if you would like to ask a question, as several of you have now, now's the time to type in your question in the question box if you haven't already done so. And I'm going to go through a couple here, but here's that opportunity. So, Ryan, this is from Matt Trout. Ryan, did you mention that the Department of Transportation operates separately from DAS? If so, why? Why do they do that? And what projects then fall under their umbrella that DAS doesn't?
I'll start with the latter. Road construction, horizontal construction is primarily within the jurisdiction of the Iowa Department of Transportation. They do not use the ConsensusDocs for their road construction projects. They have their own custom contract that they use. Why? Because that's the way the statute is set up, such that the construction of our roads is within the Iowa Department of Transportation and not something that DAS is responsible for doing. DAS primarily takes care of vertical construction projects, I suppose, for the executive branch of Iowa state government. Some horizontal projects, but primarily vertical construction. So Department of Corrections, Department of Human Services, Department of Inspection and Appeals, Historical Building, all the other state departments here on campus and around the state that have construction needs use DAS to have those projects administered, roads not being among them.
I've got another question from Eric. How did ConsensusDocs tie in with a lean approach to delivery? And lean is with a capital L, and I might have some thoughts on this, but I wanted to give you the first chance on that one.
Sure. Well, using our construction managers and our more experienced construction professionals, we try to be more efficient in our construction, and I think the ConsensusDocs facilitate a more efficient process for us to accomplish our construction work. A particular example I can't come up with off the top of my head, but they are lean friendly, and that is, making lean decisions is dependent upon having people that understand how to make those decisions, and we certainly have those people in process or working for us and working with us.
And I'm not sure if this was the intent of Eric's question, but there is a movement within the design and construction industry to try to come up with greater efficiency and techniques. There's 40 organizations that are part of ConsensusDocs. One of them is the Lean Construction Institute, and I know that AGC of America has a lean forum as well. And the essence of that is developing a lean curriculum. The essence of it is that even in design, bid, build, and certainly design, build, team at risk, but really with focusing maybe even on some of the ConsensusDocs IPD contract, the 300, incorporates a lot of lean principles that include really trying to drive out waste and inefficiency throughout the process by coming out with real-time deliveries, making sooner collaboration between contractors and design professionals and owners early in the process to spend more time planning so you spend less time almost eliminating RFIs in the field and using new technologies, but it's really focused on the production process of designing construction and making it a lot more efficient, real-time, and there's the general sense of the way that buildings get built and sometimes contracts are written. You're looking to protect your bottom line, and so you have your contract, but the teams aren't really collaborating holistically, so you can't make, say, a reliable promise that one subcontractor is going to finish on a given day and the other person's going to do a quick and efficient handoff. So there's really a lot to it, pool planning and pool design and such, and it's really an interesting field that certainly we talked about the dispute resolution as being more lean and creating some efficiencies, and then there's sort of a secondary level of lean construction that's really a whole movement and field. The last thing I'd offer, we kind of talked about the contracts, and I think contracts are part of the efficiency, and the construction has been maybe slow to improve in efficiency. In the old AIA documents, or the current AIA documents that are published and DAS used to use, there was actually a prohibition from the architect, for the owner to talk to the contractor, because everything was supposed to be funneled through to the architect. And that's certainly something that's a difference in ConsensusDocs. And Ryan, I think you mentioned how teamwork and collaboration is the key to success, and that's something that you want your contracts, no matter what you're using, to make sure that they actually encourage people to talk and resolve problems.
Absolutely. Meeting early and often with all of the players that have a vested interest in a successful outcome of the project is very, very important. And having selecting good construction managers and good design professionals who are willing to do that is necessary.
Hey, one quick question. I have no idea, and this isn't something that's really in the contract, but in the process. Do you have any co-location between the design professionals and the contractors, or even the CMs in the field?
No, I don't believe they're co-located. I think the construction manager and the design professional and representative DAS certainly work together, but I don't think they're actually co-located together.
Now, another question my question, I'll take some prerogative as a moderator, is the folks that you have who are the CM agents on, I think you said there were 6 of them that are on contract?
Yeah.
Yeah. Are those folks prohibited from bidding on the actual building work as a general contractor? Sorry, what was that?
Yes, I believe we do prohibit them from bidding on, at least on projects that they're working on.
Right. Right, yeah, I meant to ask it that way. Yeah. So here's a question from Rick Reed. How much authority does CM agency exercise in resolving disputes that rise to the level of mediation arbitration?
They're still the agent of DAS, so they have as much authority as we. The contract itself does not vest in them the authority to make a decision on our behalf. They would have to go through, work with one of our leaders to make a decision with respect to dispute resolution. However, that being said, despite the fact that the contract doesn't vest in that authority, the reality is we have so much, our volume is so high that we rely upon them to make virtually most of our decisions are made going through the construction manager, and our relationship with them is pretty good. So the reality is we do rely upon them in disputes, but there just aren't 2 problems. 1, the contract doesn't vest in the authority. 2, we haven't had very many disputes. But 3, we do have a really good relationship with them. Were a dispute to arise, we would, of course, rely upon them heavily to make such a decision.
Do you allow the CM agent to speak for you in regards to change orders?
Yes, but the change order is still ultimately signed by by the owner.
Here's a question from Lane. Are the Iowa modifications to ConsensusDocs available on their website, and if so, what is the address?
I can give you that and post that later. But yes, I think our contracts are available via the web, and I can provide that to you, Brian, if you want to provide that to other people. I don't have the address in front of me.
No worries. I'll send it out.
If they want them, a good way to do that is to have them send me an email, and I'll send them a copy attached to an email.
Okay. I'll make an effort to put that in the materials that we send out with the PowerPoint presentation. Here's a question from, actually I'm not sure who it's more of a company name, so I'm not sure this individual asker. Do you see any further areas of improvement in the construction process at DAS?
I've no doubt that there are ways that we can continue to improve our project management and administration. We're still, we're still in the infancy of using the web project management based software, the web-based project management software. So I know there are ways we can improve that. I know that we can improve our contract to more accurately account for that use of web-based software. I think also we can still there's room for improvement with respect to leveraging our construction managers to be able to do more work at a higher rate of efficiency and speed. So go ahead.
Sorry, Ryan. A little delay on the audio. What software do you use, and was that a difficult evaluation process?
Our project, the construction team actually made the choice, and we used the EA web-based project management software.
Sorry, I didn't mean to cut you off before. If you could elaborate.
EA Docs.
Mm-hmm.
And that's my understanding. That's going well. It's still something we have been using it for an extremely long amount of period of time, but it's something that we believe has made improvement, and our vendors are buying into it. But I think that continuing to improve our ability to use that software and that tool will be something that will make us more efficient, and I think again help us sort of lead the way with respect to administering projects as a public entity.
Here's a question that I particularly like from Paul Hungley. What are the avenues for learning details about ConsensusDocs without purchasing them at this time? And Phil, Ryan, this is maybe a good example of that. You kind of were in probably at a little bit of a dilemma at some point, although you were personally probably familiar with them. If you had in making the purchase decision for ConsensusDocs without having access to them, that's fully access them. Feel free to talk about your experience and us working together on that.
Yeah, so after meeting with so I was generally familiar with the ConsensusDocs as a form contract and had worked with clients on them before coming to DAS. Certainly wasn't as familiar with them as I was the AIA document. One, I found the internet to be a great resource. Two, I was able to reach out to the ConsensusDocs organization itself, and Brian, and ask for information related to them, and the information came quick. And three, if I encountered more than one expert at various attorney CLE presentations and construction organizational gatherings where the ConsensusDocs were talked about. So there is a ton of information out there if you just keep your eyes open.
So, and I'll mention this, and when you were going through this, it wasn't on their website, but we actually have a link for, well, we do have the ability to download samples, right? And those are excerpted samples. But if you need a full copy, we actually have a link where you just make a quick request where you can request, I believe it's up to 3 samples of documents. And then in particular, if you're an owner organization, we're willing to work with you and provide you access to the software so you can kick the can before doing it. I mean, you can buy a subscription and you get 30 days to return it if you're not happy. But certainly we've done a lot of trials for, I think, all COA members and CURT members. I don't think we've done it for NASFA members, but we should make that offer of, do you want a free trial to use the software? Because the whole point of what we're trying to do is, well, first off, owners are the keys to moving the software, to this industry forward. It does take an enlightened owner, so to speak, but it's usually, the enlightened owner is a funny term in my mind. They need sort of help in moving that direction, and as opposed to looking out for their own individualistic short-term line. But we're really willing to work with folks, and we want people to use the documents, and we're trying to make that as easy as possible. I'll update the PowerPoint so you can have my contact information as well, my specific email address, but you can always do, I think it's info@ConsensusDocs, or maybe it's support@ConsensusDocs.org, and all that information is on the website at ConsensusDocs.org. Someone made a comment about contractors. I'm not sure if this is too much of a question or a comment, but I don't like how a contractor has to indemnify the architect, which pervades a lot of owner documents, and they believe that it's self-serving to require the contractor to indemnify the architect. I don't know if there's, Ryan, if you want to comment on that, or if I should move on.
Sure. That was the indemnification requirements of the standard consensus doc form was a subject of a lot of analysis, and ultimately what we did was we sort of regressed back to more standard traditional contract indemnification requirement, and that is the parties to our consensus docs contracts are only responsible for indemnifying the parties with whom they're in contract with. So the owner is responsible for indemnifying the contractor and vice versa. The contractor in our project format is not responsible for indemnifying the architect. The consensus docs, just like other form contracts, are very easily modified, so we made that modification.
And then you make that standard throughout your contracts, as we talked about before.
And we did that as a, again, as a public owner, we didn't want to, where we have to follow the design bid build method, which is a more strict, and the collaboration has to come as a result of, the builders have relationships and efforts by our people. The contracting we didn't want to be complicated, so we just made a simple change there, such that the parties only indemnify folks that they're in contract with. So again, our contractors do not indemnify architects. And vice versa, architects do not indemnify the construction managers or the contractor.
Have you tweaked your standard documents at all from the initial adoption of Consensus Docs?
There have been minor tweaks. Not significantly, I don't think.
Did you change the period for the warranties? Let me think if I can say this correctly. Essentially, the warranty period for defective construction. Did you change that provision? I shouldn't ask you on the spot like that, but well, maybe I'll ask you offline afterwards. Yeah. Would you prefer to be able to use? Here's a question from David. Would you prefer to be able to use design build on projects? Are there any efforts underway to get legislative authorization for design build? What are the obstacles to legislative authorization of design build? And that's from David.
Well, I am merely a servant of the state and have no opinion one way or the other on design build, of course, because the legislature controls my department. So with respect to obstacles, I mean, the obstacles are there are folks who believe that the most, sure way to make sure that a project that a vendor is contracted with fairly is to use the design bid build method. One way or the other, though, I'm not positioned to make comment on that. Sorry.
I'll just say this: is the AGC created a free web page that covers all the states that have design build authority one way or the other, and I believe Iowa is one of the few states that doesn't have design build authority. But it was I'm interested to hear, Ryan, about what you said about that there's been some recent developments in the university system that may be able to do it. at the public level?
Yeah, for the most part, the state still is prohibited to do it. I do believe that the University of Iowa is going to use that delivery method on a couple of projects in Iowa City. The Board of Regents governs the University of Iowa, a different area of Iowa law, and they have some special authority to do some different things. But yeah, generally speaking, Iowa, I think, is one of just 4 states that does not allow for the project to be constructed using the design-build method.
Is there, I mentioned before about how the incredible results that VAS has gotten in the past few years with changing its program. Is there any other efforts that you're aware of in Iowa or elsewhere that leveraging the positive experience from presentations at CO or presentations like this to build off the success that you're aware of?
There was an effort, I think, at the with the university system to make improvements there, and it's been a challenging process, my understanding, and I don't know where they're at. Frankly, I'm not working with them on that, but there's been an effort, and they've made some improvements there, and I think it's something they're still working on. Other governmental entities, I'm not familiar. Don't have knowledge of any other public entity within the state that is in the process of revamping its public sector construction program.
Here's a question from Dale, and it basically is saying that the general contractor takes on all the risk when it's for subcontractor defaults. And I think the question is, or I might be surmising this, is why doesn't the state require the subcontractors to be bonded? And I'm not even sure if it's particular to Iowa, but
well, with respect to our contracts with our prime contractors, that's controlled by statute. It's not a choice that DIS makes. It's a legal requirement. Iowa Code Chapter 573 requires that contractors who contract with the state for public improvement projects buy a surety bond for the project to guarantee that their work will be completed. That's why we require bonds with our prime contractors.
But not for the subs. It's not explicit for the subcontractors to be bonded. So I think the question is, if there's an extra cost and the general is bidding on projects and is selected only by their low bid,
Yep.
But you're saying that you don't have statutory authority to require the subs to be bonded.
I don't know if we have we may have statutory authority to require it. We just are not statutorily required to require it. And frankly, I don't believe that the construction market in the middle, at least in Iowa, has adopted the industry norm is not for every subcontractor to be required to carry a bond. We're just not, based on my perception, that's just not normal like it is in Texas and California. It's an area of the construction market that's yet to be fully developed within, at least, that's based upon Ryan Land's personal opinion. I don't think it's fully developed yet.
Very good. This is going to, we've had a lot of questions. This is great to have the discussion, and I've enjoyed it. I've got one last question before our time is going to be up for the day, but don't sign off. I do have one last thing to say after Ryan answers this. You mentioned that there's a statutory prohibition against design build. Are you able to use CM at risk?
No. No, I'm not allowed. No, DAS is not allowed to use CM at risk. The law doesn't say no design build. The law doesn't say no CM at risk. Instead, it sets forth requirements as to what we have to do. And when you do what you have to do, you are necessarily prevented from doing something like CM at risk or from design build.
Well, very good. Ryan, I want to thank you for sharing some insightful information about the success that you've experienced at Iowa in making some dramatic improvements. I want to thank everybody for taking time from their busy days to listen in. This presentation, again, will be delivered to all registered attendees, both the PowerPoint as well as the audio with the WAV file, if you will, with the slides sort of being a video. I'd also want to ask you to there's going to be a couple questions that pop up when you sign off. Please take the time to take the survey. We really do use that information and feedback to evaluate what's being delivered and making improvements. Again, thank you very much, Ryan. If you have any further thoughts before we sign off?
No, thank you for the time and the opportunity.
Well, thank you, and everyone have a wonderful rest of the day, and happy contracting.